slander per se. If the spoken defamatory statement falls into one of four specific categories, it's considered so inherently damaging that special damages are presumed, just like libel.
What are those four slander per se categories?
They are statements accusing the plaintiff of 1. Committing a serious crime, often one involving moral turpitude. 2. Having a loathsome disease, historically leprosy or venereal disease, maybe contagious diseases today. 3. Conduct that adversely reflects on the plaintiff's fitness or competence in their business, trade, or profession. Or 4. Serious sexual misconduct. Historically, unchastity in a woman, now applied more broadly. If it's slander per se, no need to prove special damages.
Okay. Now, a really critical point in defamation, especially with public figures, falsity and the defendant's mental state. This is where the First Amendment comes in strongly.
Absolutely crucial distinction. If the plaintiff is a public official or public figure, or if the statement, even about a private person, involves a matter of public concern, then the plaintiff has the additional burden of proving two things. 1, that the defamatory statement was false, and 2, that the defendant made the statement with actual malice.
Actual malice again. Knowing falsity or reckless disregard for the truth.
Exactly. That's a very high bar, protecting speech about public matters. Now, if the plaintiff is a private person, AD, the statement is not a matter of public concern. The rules are different. The plaintiff generally does not have to prove falsity. Instead, the defendant can raise truth as an affirmative defense. And the plaintiff usually only needs to prove the defendant was at least negligent regarding the statement's truth or falsity, not actual malice.
Okay, so the standard really depends on who the plaintiff is and what the speech is about. What are the main defenses to defamation?
The absolute defense is truth. If the statement was substantially true, there's no defamation. This is a key difference from some privacy torts, remember.
Right. Truth is king in defamation. What else?
Consent, of course, if the plaintiff consented to the publication. Also, there are various privileges. Absolute privileges provide complete immunity, regardless of malice, for statements made in certain contexts, like judicial proceedings, legislative debates, communications between spouses, or required publications.
And qualified privileges.
Qualified or conditional privileges protect statements made in good faith on matters where the speaker has an interest or duty, or the recipient has an interest, or it affects an important public interest. Examples include references for job applicants, reports of public proceedings, or statements made to protect one's own legitimate interests. However, these privileges can be lost if the speaker acted with actual malice or exceeded the scope of the privilege.
Okay. Now let's move to invasion of privacy. You mentioned truth isn't always a defense here. This covers 4 distinct torts, right? The IFLAU mnemonic.
That's a helpful way to remember them, yes. IFLAP is for intrusion upon seclusion. This is intentionally intruding, physically or otherwise, upon the private affairs or seclusion of another in a manner that would be highly offensive to a reasonable person. Think hidden cameras in a bedroom, illegal wiretapping. Importantly, no publication is required for this tort.
Just the offensive intrusion itself. Okay.
F is for false light. This involves publicly placing the plaintiff in a false light in the public eye in a way that's highly offensive to a reasonable person. It's similar to defamation, but the harm is the offensive false portrayal, not necessarily damage to reputation. For matters of public concern, the plaintiff must prove actual malice here too.
So maybe attributing beliefs to someone they don't hold. Got it. L.
L is actually part of the next one, which is A for appropriation, specifically misappropriation of the right to publicity or name likeness. This is the unauthorized use of the plaintiff's name, picture, or likeness for the defendant's commercial advantage. Think using a celebrity's photo in an ad without permission.
Okay, commercial use of identity. And P.
P is for public disclosure of private facts. This involves the public disclosure of private information about a plaintiff, where the disclosure would be highly offensive to a reasonable person, and the information is not of legitimate public concern.
And crucially, the facts disclosed here can be true, right? Unlike defamation.
Exactly. Even if the embarrassing facts are true, their public disclosure can be tortious if they are private and not newsworthy. However, this tort is often disfavored by courts because of potential conflicts with the First Amendment's protection of truthful speech, especially if the matter has any arguable public concern.
So, key takeaways for privacy torts. 4 types. Truth is generally not a defense, except maybe relevant to false light's malice standard. And the right is personal, usually ending at death.
That's right. And generally, no special damages need to be proven. Emotional distress damages are usually recoverable. Consent is a defense to all four types, and the absolute and qualified privileges we discussed for defamation can also apply to false light and public disclosure claims.
Okay. Next, let's look at torts involving misrepresentation, intentional misrepresentation, also known as fraud or deceit.
Right. This requires the plaintiff to prove several elements. 1, the defendant made a misrepresentation of a material fact, or sometimes opinion, intentional law. 2, the defendant knew the representation was false or acted with reckless disregard for its truth. This intent is called scienter. 3, the defendant intended to induce the plaintiff to rely on the misrepresentation. 4, the plaintiff justifiably relied on the misrepresentation. And 5, the plaintiff suffered actual pecuniary damages as a result.
So a knowing lie, intended reliance, actual to justifiable reliance, and actual economic loss.
Pretty much sums it up. Puffery or vague opinions usually don't count as material facts, and damages are required. No nominal damages for fraud. Consequential and sometimes punitive damages might be available, but recovery is generally limited to economic loss. Emotional distress damages usually aren't awarded for fraud itself.
And there's also negligent misrepresentation, a lower standard.
Yes. This applies typically when the defendant is in the business or profession of supplying information for the guidance of others in their business transactions, like accountants, surveyors, lawyers. If they negligently provide false information to a plaintiff who justifiably relies on it and suffers pecuniary loss, they can be liable.
Is the scope of liability broad? Can anyone who sees the information sue?
No. Liability for negligent misrepresentation is usually limited to the plaintiffs, or a limited group of people, for whom the defendant knew the information was being supplied, and only for reliance in a transaction the defendant intended the information to influence. It's narrower than general negligence liability. Standard negligence defenses apply. Damages are usually reliance. Damages the losses suffered from relying on the false information.
Okay. Now let's shift to torts that protect business relationships. Intentional interference with business relations.
Right. This category primarily covers two torts. First, intentional interference with an existing contract.
Interfering with the contract.
Elements. The plaintiff needs to show 1, a valid contract existed between the plaintiff and a third party, not the defendant. 2, the defendant knew about the contract. 3, the defendant intentionally acted to interfere with or induce a breach of that contract using improper means or motive, exceeding fair competition or free expression. 4, the interference actually resulted in a breach. And 5, the breach caused damages to the plaintiff.
Can interference ever be justified?
Yes, certain conduct might be privileged or justified. For example, if the interference was motivated by protecting public health, safety, or morals, if the contract was terminable at will, or sometimes if the defendant is simply a business competitor using recognized competitive methods, though competition usually isn't a defense for interfering with an existing contract, only prospective ones.
Which brings us to the second tort. Interference with prospective economic advantage. No existing contract here.
Correct. This tort involves interfering with a potential business relationship or expectancy before a contract is actually formed. Because there's no existing contract, the plaintiff generally has to show more egregious conduct by the defendant to win. The interference usually must be independently tortious, like defamation or fraud, or otherwise considered illegal or improper based on a balancing of factors. Simple business competition, even if intentional, is generally not enough here unless wrongful means are used.
So harder to prove than interference with an existing contract.
Definitely. The law gives more leeway for competition when there isn't a binding contract already in place.
Are there other business torts we should briefly mention?
Sure. Theft of trade secrets is one requires proving a valid trade secret existed, the owner took reasonable precautions to protect it, and the defendant acquired it through improper means like breach of confidence or industrial espionage. There's also injurious falsehood, which includes things like trade libel, malicious publication of false statements disparaging plaintiff's business property or products, and slander of title, malicious publication of false statements disparaging plaintiff's title to real property. Both of these typically require proof of falsity, malice, and special damages. Truth and fair competition are defenses.
And finally, torts involving misuse of the legal system.
Two main ones here. Malicious prosecution arises when someone initiates or procures criminal or sometimes civil proceedings against another, intentionally and maliciously without probable cause, for an improper purpose, and the proceedings terminate in favor of the person sued, the original defendant, now plaintiff. Damages can include legal expenses, lost work time, harm to reputation, and emotional distress. Judges and prosecutors generally have absolute immunity.
Okay, and the second one?
Abuse of process. This is different. It occurs when someone uses a legitimate legal process, like filing a lawsuit, issuing a subpoena, in a willful or improper manner to accomplish an ulterior purpose for which the process was not designed, causing damages. The key is the misuse of a properly issued process for a collateral, wrongful objective, not the wrongful initiation of the suit itself. 9x. Connecting the dots, bar exam strategies, and key relationships.
Wow. Okay, we have covered an incredible amount of ground in the world of torts law, from intentional acts to carelessness to strict liability, property, reputation. It's a lot. Before we wrap up, let's take a moment to try and connect some of these dots and offer some practical strategies for tackling torts on the bar exam.
Absolutely. It's really vital after learning all these individual rules to step back and see the bigger picture, the interconnectedness. Remember how concepts like intent and causation kept reappearing across different torts?
Yeah, they're like threads running through the whole subject.
Exactly. And understanding those fundamental differences in the required mental state, intentional conduct versus negligent conduct, failure to use reasonable care, versus strict liability, no fault required. That's your first big sorting mechanism when you see a fact pattern. Ask yourself, what was the defendant's state of mind, or is it irrelevant? That immediately helps narrow down the possible torts involved.
That's a great starting point. What are some of the other really essential distinctions, those pairs of concepts that are frequently tested against each other that we absolutely need to master?
Oh, there's several classic pairs you need to have crystal clear. I.e. versus NIDE. Know the different elements, especially the high bar for i.e. extreme outrageous conduct, severe distress, intrecklessness, versus the specific requirements for NIDE, zone of danger or bystander rules, often needing physical symptoms.
Okay.
Trespass to chattels versus conversion. Remember, this hinges entirely on the degree of seriousness of the interference with personal property. Minor interference, trespass; substantial deprivation, conversion.
Right, the scratched car versus the burned car.
Exactly. Necessity defenses in trespass to land. The crucial difference between private necessity, qualified privilege, liable for actual damages, and public necessity, absolute privilege, no liability for damages if reasonable.
Got it.
Negligence versus strict products, liability versus warranty, especially knowing when pure economic loss is recoverable, usually only warranty, and the different elements and defenses for each theory when a product causes harm.
That three-way distinction is key for products.
Definitely. Defamation versus invasion of privacy, particularly the role of truth, defense to defamation, generally not to privacy torts like public disclosure, and the different interests protected, reputation versus personal space feelings, joint and several liability versus pure several liability, how damages get apportioned when multiple defendants are at fault, know the default rule and the modern trend,
And finally,
contributory fault versus comparative fault, understanding the old harsh rule versus the modern approach of reducing damages, and the crucial differences between pure and partial modified comparative fault systems.
mastering those distinctions seems absolutely vital for issue spotting and analysis on the exam.
It really is. They represent common points of confusion and therefore common testing areas.
So bringing it all together, how can someone approach a complex torts fact pattern on the bar exam? Is there a framework for spotting the issues systematically?
I think having a mental checklist is incredibly helpful. When you read the facts, try analyzing them through these lenses. First, what was the defendant's conduct? Was it a sale or manufacture of a product? Was it speech? Was it an abnormally dangerous activity? Was it fraud or misrepresentation? Categorizing the type of conduct helps focus your thinking.
Okay, categorize the conduct.
Second, what was the defendant's mental state? Was it malicious, intentional, reckless, merely negligent, or is mental state irrelevant? Strict liability. Nailing down the mental state is critical.
Conduct, then mental state. Next.
Third, what was the plaintiff's harm? Was it physical injury, property damage, purely emotional distress, economic loss, harm to reputation? Identifying the specific harm points you towards the relevant torts and damage rules.
Makes sense. Harm dictates the potential claims.
And finally, do any defenses apply? Think about the specific defenses relevant to the potential torts you've identified. Consent, self-defense, comparative fault, privilege, statute of limitations. Always consider defenses.
That's a really powerful framework. What's fascinating here is how these categories, conduct, mental state, harm, defenses, aren't just academic concepts. They feel like practical tools you can actually use to dissect a complicated story under pressure.
That's exactly the idea. It provides a structured way to approach any torts problem, helps ensure you don't miss key issues, and guides you towards applying the correct legal principles. It's your analytical toolkit.
Well, we have certainly navigated the intricate, sometimes confusing but always interesting world of torts. From intentional harms and negligence, through property invasions, strict liability, and protecting reputation and business interests. Hopefully you, our listener, now have a much more robust framework for understanding these core concepts and how they relate to each other. A true deep dive into what you need to know.
That's the hope. We've covered a lot, but the goal was to provide that clear roadmap connecting the pieces. The next step for you is to keep revisiting these areas, maybe draw out your own flowcharts or comparisons, and definitely apply this knowledge to practice questions and hypothetical scenarios. That active application is absolutely key for locking it in, especially for the bar exam.
Absolutely. Practice, practice, practice. And just as a final provocative thought for you to chew on as you continue your studies, consider how the evolving nature of our world, things like social media, artificial intelligence, new technologies, might continually challenge our traditional tort definitions. What constitutes publication online? What's an intrusion in the digital age? What might be considered extreme and outrageous conduct generated by AI?
That's a really interesting point.
The law is always adapting. It's a living thing. But your understanding of these fundamental principles we've discussed today, duty, breach, causation, intent, defenses, that foundation will equip you to analyze and tackle not just current tort law, but its future complexities as well.